All rise. Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We're here on our case number 1, CACV 180438, Knox versus Ravencrest, Arizona Registrar of Contractors. So both of you know that each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would do us the favor when you approach the podium to give us your name and the name of your client for the recording. We have read the briefs, and we've studied the iterations of the statutes over time, and we've also reviewed closely the record in the case, and we've discussed the matter in a conference together. So with that, you may proceed.
Good morning, and may it please the Court. Assistant Attorney General Michael Rain on behalf of the Arizona Registrar of Contractors. It was error for the Superior Court to have granted the Knox's summary judgment motion and to have denied the ROC's cross motion for two main reasons. The first of which is that under the Recovery Fund eligibility statute 32-1131, it required that the Knox's had property that is classified as Class 3 property. The Knox's don't have such property. And secondly, the Superior Court improperly bound the ROC to admissions of fact that the contractor was implied to have made by virtue of its default, despite the ROC having appeared and defended and on many occasions reserved and expressed that it had objections.
You know, on your second point, didn't the ROC though respond? Well, actually, as I remember, there were cross motions for summary judgment on the merits, and the ROC had the opportunity to argue about the contract and put in any evidence that it had on that point.
Well, if I understand, Your Honor, do you mean at the summary judgment stage?
Right, on the cross motions for summary judgment.
It did. It did have that opportunity, but as you read the Superior Court's minute entry, the only basis really articulated was that the ROC was bound by these facts. And it said, I don't want to hear you on those issues, which were the merits that the ROC would have argued.
But our review of summary judgment will be de novo. So if we agree with you that the court should not have precluded the ROC from raising any defenses, we can address those defenses.
Yeah, and I would ask that you do, and that you enter summary judgment in favor of the ROC, primarily on that statutory interpretation ground. And I'd argue that you would deny summary judgment if those facts that the ROC wanted to dispute were allowed to be disputed, that you should deny or recommend denial of this Knox's summary judgment motion. And I'll just continue on this second point while we're talking about it, which is to say that there were questions of fact. Had the ROC been allowed to raise their disputes?
Well, was there other evidence that the ROC didn't offer but should have offered?
No, not additional evidence as much as that its points were more addressing the evidence that the Knox's had raised and how it was essentially inconclusive or not of a sufficient character to carry their burden. One of the issues that the Knox raised is that this was a refundable deposit, and the evidence that they present is a self-serving hearsay affidavit from Mr. Knox saying, we had this modification to our agreement. Look at this email. Well, when you look at the email that they presented, the question is whether the deposit was refundable, and the email just said, I owe you a deposit. I'd like to get started right away. I'm waiting for my bank financing, so I'll pay you with my own money to get the work going. And when the financing comes in, we'll swap the money. That's not even a refund. That's just changing the deposit money from coming from the Knox's to coming from the financing. There's nothing in that contract that makes the deposit refundable. The contract had an integration clause that said it could only be modified by a writing signed by both parties. We don't see anything from the contractor. We see this one email saying, I make this proposal from the Knoxes. You don't see any response from the contractor. All you have, and as I noted, the email itself doesn't actually modify the contract as the Knoxes suggest it does to make a refund. But you don't see anything from the contractor. You just see the Knoxes hearsay affidavit saying, look, we modified this contract. And that's just contrary to the face of the contract and what it would have taken to modify that contract. That's the refundability of the deposit issue. In addition, there was a question, for example, of whether the property could be classified as Class 3. That has never really been briefed. The Knox's argument has always been back at some
But you
time.
briefed it now, so let's talk about that.
Exactly. The Knox's argument had always been, at some point in the past, we would have qualified, but you'll not find anywhere in the record where they actually presented that argument, presented the language from the time when they think we should be looking at the tax code and applying that definition and then applying that to any facts to say, look, we would have qualified. You don't even see that. And so what you saw from the Knoxes was probably a summary judgment motion that didn't even shift the burden to the ROC to respond.
Well, let's talk about the statute.
So the statute 321131 says that you need property that is classified as Class 3. And we cited our supplemental authority, the recently decided Waltz decision. There you had a medical marijuana dispensary that needed to demonstrate that it is compliant with local zoning. And this court said the use of that word is, the present tense use of is, required that you had that character, that your property was of that character at the time of application.
So meaning it had some permit to be occupied,
Essentially,
an occupancy permit.
And I would say that at least the way I think it's most instructive is that they were essentially applying a separate governmental entity's existing determination on a fact. An entity, a governmental entity that is expert in those matters. Local zoning at the city level, here at the ROC level, it would be the county assessor. They are the ones who look at the quality of property and determine the appropriate tax classification. And so the ROC says, look, the plain meaning says it is classified as Class 3. We want you to adopt the plain meaning. It's the Knoxes that say, let's look a different direction. But no one ever found the statute was ambiguous, and I argue it doesn't result in any absurd results. It's sound policy to say to the ROC, we don't want you messing around in the world of what's the appropriate classification of real estate. That's not the ROC's expertise. Instead, what the legislature gave.
But what about the language in 321131 that allows, that states that an injured party includes one who intends to occupy a residence?
You can have Class 3 property that you don't occupy. If I wanted to.
But it's only if it's the primary resident of your relative, right?
Well, and I'm just speaking generally as it might apply to both statutes. The example I would think of is if I wanted to, if I could afford to remodel my home and it was going to be such a large remodel that I had to move out for a while. It was Class 3. I was living in my property. It doesn't change classification because I'm going to go stay at the Holiday Inn for a couple months while someone's in my house making it.
It does.
Fresh.
What does the phrase "actually occupied" mean then?
I don't understand the question. I'm
Actually occupied.
sorry. In the
if
ROC
you
statute.
talk about plain language, that seems pretty plain. That means you're inside of it.
Yeah, well, and I don't know. Are you referring
You're
to
living in it.
Yeah. Well, the ROC statute.
Is means is, then doesn't actually mean actually, and occupied mean actually somebody's in the property. So if you move out for 6 months and nobody's there, then it's no longer actually occupied.
Well, but the ROC statute allows for both actual occupancy or intent to occupy. And
That's Judge Johnson's question. It doesn't. Okay, so intend to occupy.
And maybe I can answer it this way, which is to address the way the Knoxes have argued
Intend to occupy when?
At some point in the future, obviously.
Right. Did the Knoxes not intend to occupy?
They
in the
surely
future?
appear to have intended to occupy the property, and no one has said they don't meet that part of the Recovery Fund eligibility statute. But it doesn't just say that you intend to occupy. It also says, in plain meaning words here, that you also need it to be classified as Class 3. And the Knoxes have argued this 2011 amendment to the tax code just completely obliterates these parts of the RLC's recovery fund. And my answer, I guess, to Judge Johnson and you is that that's not true. I could remodel my home. It's class 3, but I'm not occupying it because it's under some sort of remodel. I intend to occupy it in the future, so I wouldn't be prohibited because I'm not literally residing in it.
How would your construction of the statute apply to a new build?
A new build, similar question. And I want to take one quick step back on that to answer that question, which is to say that it has not been determined, I believe, by the language of the tax code that the land of a character of the Knoxes could not qualify for class 3 tax status, I should say. That's
There's
the
no home
presumption.
there. There's
Well,
no
when
occupancy permit. Oh.
Well, when you look at the 2011 amendment, that's the one they say, look, this changed it. You used to be able to just intend to occupy and get class 3 status, but in 2011, everything changed. And in the citation of supplemental authority, we pointed you to the 2011 change. It had no impact on the intent to occupy issue.
We have been through all the legislative
understand.
history ourselves, although the briefs were not overly helpful in that regard.
I understand. I hope that the supplemental authority was at least gave you the head start on evaluating that claim. But in terms of a new build, I would just make that point that I don't think there's been any argument of any sufficient character from the Knoxes to say that a new build can't qualify for class 3
So
before the home is done.
But you told us before that that class 3 requires an occupancy permit.
No, I didn't mean to, if that was the impression I gave. What I'm telling you is 321131 requires class 3 treatment. And the argument I'm also making is that I don't think you've seen any argument from the Knoxes that land that has a completed residence can't also qualify for tax
So
free.
you're suggesting, I mean, is there evidence of this, or can you point us to a statute that allows you? Can I go to the assessor, if I've got vacant property, and go ahead and get that reclassified to class 3 property? Say I intend to build on this.
You may.
Someday.
Where do we get that?
Well, number one, the only reason that you're told you can't do that is that the Knoxes point to the 2011 amendment. And when you look at that, it certainly didn't say, it used to be you could have intent to occupy, but now in 2011 you can't. The 2011 amendment didn't do that.
Well, focus on the current language of the tax code.
The current
Are you
language.
suggesting that the tax code would grant class 3 status to a property that doesn't have an occupied home on it?
Yes, I'm suggesting that that is something that the assessor could determine in its expertise.
But you're not saying it.
Are you aware of any situations where that actually has happened?
Real and personal property, that
Yes,
is
there is a
occupied.
case. I don't have the citation for you. It's called Hayden Properties. And you'll find it as an interpreting case of 42, the tax classification
Hayden
statute.
Properties?
Hayden Properties. And then within the related statutes under Title 42, you'll find a statute about intent to occupy. But look at the Hayden Properties. I'm sorry we didn't cite it for you. That's our mistake. But the Hayden.
You haven't even given us the name.
Well, I'm giving it to you in answer to your question. But from the ROC's perspective, living in the world of tax classification was not our point. The point was that the legislature created a statute that provided the ROC with this objective and easily ascertainable qualification, and it says it needs to be classified as such now. So the question of what it could have been in the past or presently had they gone to the
Okay,
assessor.
we're focusing now.
Yeah.
Now, I don't know that you've answered my question. How does the ROC think that the 321131 applies in the case of a new build? What I hear you saying is maybe it could have class 3
It could.
classification.
At the time of application, it could.
What application of what?
Application for the recovery fund.
If
excuse me.
what?
If at the time of applying for the recovery fund, you had gone to the assessor and had your property designated as class 3, and let me just give you an example of how that could play out. If I'm building a residence and it's a new build, it starts with bare land, but I don't get to the completion of the residence, the contractor's done something wrong, I go ahead and get a judgment, or I get an administrative civil penalty against the contractor for that violation. I finish the residence. I have been damaged.
So-
I had to spend money to fix it.
So you're saying that the owner would have to hire someone else to come in and actually build a property that would be a class 3 property?
That is one way that it could happen.
What
And
other way?
Another way is, and I know it's frustrating to you because we haven't put it in front of you well, but the other way is just my understanding of the tax code, related statutes to the definitions of different classes of property allow for intent. And the Hayden Properties case, in that case, essentially what had happened is you had a developer who had numerous lots of various levels of development. And some of them had, the pipes laid, and some of them had some drywall up, at various stages. And it comes down to near the end of that opinion where the court looks at one that just had the lot. And they said, I don't remember if it was class 3, but they were wondering whether it was a residential character. It might have been 5 back then, 5 became 3 subsequently. But the point of the court was, it was a totality of the circumstances evaluation that the assessor would make to determine whether it was pointed in the residential direction sufficiently enough that they would give it class 3 status. So I think that that's one way to do it, but that's not been this case. There's nothing in the record about the Knoxes ever evaluating that question with the assessor. And the ROC would urge you to not make the ROC the new assessor, where in each case where you have a recovery fund claim, they have to evaluate. Not, are you class 3, which is pretty simple. You go online, you find out if you're class 3, but actually, not even if you're class 3 under the current law, but whether you would have been class 3 under some old law. And I'd ask you to consider this. What if you're class 3 now and you go to apply the recovery fund? Under their argument, it's kind of irrelevant. You need to go back and find out if you were class 3 at the time the recovery fund was adopted.
We're not so concerned about past or present. Okay.
I understand. It's just an untenable construction that we would always look not at what you're currently classified as, but what you might have been classified by the assessor who's not involved in the case at some point in the future.
What about the provision in 1132 allowing an injured party to recover for a deposit that's not been returned? How would that apply in the context of a new build? Isn't that this situation? Doesn't that inform our construction of the statute?
I don't believe so, because the ROC has never changed or eliminated the class 3 status. So there's multiple things that the ROC looks at to determine whether your property is sufficiently residential. And so it would have the class 3 status, and that's very objective, easily ascertainable, and they can find out the day you make an application. And in addition, they've provided for an alternative to trying to figure out what it would cost to finish a project, but instead you would have a deposit. So I could put a deposit down on a new home construction, have a deposit case. Under the ROC's interpretation, yes, I would have to eventually get my bare land to a character sufficient to get class 3 status, either by finishing the job, which isn't unheard of. The ROC, you can get to the recovery fund in a few ways. You say, here are some bids to fix my home. I want the money that is equivalent to the bids I'm submitting, or I went and fixed my home. This is what it cost me to do it. I want, and here are my receipts. So in this example I gave you, when you finished the home or when you finished it to a character that you could get class 3 status, you would present your receipts.
So say there was a new build contract and there was not a lender involved. The owner was going to pay cash. It's a $200,000 home, and foolishly, the owner gives the contractor $200,000. The contractor walks away with the money, never builds the home. Is it the contention of the ROC that the owner needs to come out of pocket for another $200,000 to get the home built before he can sue to get some of his money back?
In that unique circumstance, that may be necessary if they can't get class 3 status, but the recovery fund isn't intended to fix every single problem. And you've seen the recovery fund shrink and contract over the years in the various iterations. It used to just be property. It didn't have to be residential property. In 1981, it didn't have any tax classification requirements or residential property requirements, and they shrunk it down. And people then would have said, well, what about the person building a duplex, and they were going to live in one half? And there's always going to be, when you have these public benefits, some people who are unfortunately on the outside looking in. It can't cure every ill. And I would just note, as the Knoxes are quite sympathetic in many ways, the fact that they have bare land in this case is not because of the wrongdoing of the contractor. Contractor appears by everything in the record to have been ready, willing, and able to perform. It was the Knoxes who didn't get the financing and who canceled their contract and who are insisting on a refund that the contract didn't provide for. So at least as it pertains to these parties, they aren't in that position of a contractor having just bailed on them and taken their deposit, and that's why they have bare land. They have bare land because of their own inability to obtain financing. And I would just note, as to deposits, that the ROC, again, wished to dispute the character of this is a deposit case in that the argument that was that no work was performed. The contract itself demonstrates that work was performed. I would just remind you that contractors do a lot more than put hammer to nail. They find subs, they schedule the work, they look at plans and make managerial decisions under the definition of what a contractor does. It's a 321101. And the contract itself was attached in the summary judgment motion, and it reveals a substantial amount of work that contractor had done.
What work was done?
Well, they have a schedule down to day one when the porta potties dropped off. Every single day, I forget how many days, but let's say, over 100 days of construction, exactly what's going to happen. You see evidence in the email that the Knox has submitted as a purported modification of the contract of discussion of sub selection and engaging with subs. So the contractor had done things. He had some also non-refundable, explicitly non-refundable deposits, which suggest he'd earned them. And there's no discussion whatsoever from the contractor's perspective that, this was purely a deposit. Everything you get on summary judgment was the Knox's self-serving affidavit that is contrary to the language of the contract. I'm just going to finish because I don't think 30 seconds will do me much good later, but I would just like to point out that the Knox's whole case is based on when the recovery fund was adopted, we would have qualified. And they have a chart, but it may be, impressive, but it's inaccurate. In 1981, there was no tax classification status. It doesn't come into 86, and they've never even presented you the language from 86 so that we could second guess what would the assessor have done. We urge you to apply the plain meaning reading. It'll be clearer for both the contractors and the public and easily manageable for the ROC.
One more question. We have the various iterations of the statutes. Have you come across any other materials in the way of legislative history or writings that would inform our understanding of the sequence of events?
Oh, I did look in 94 when they, I think they added the deposit element, the Senate fact sheets, and they never mentioned the thing you want to find. I didn't find anything else earlier than that was helpful. I'm sorry.
Thank you.
Good morning. Kirk Hayes on behalf of the Knoxes, the appellees. The heart of the issue that you've got before you is whether a victim of a contractor's malfeasance may recover from the fund if they're unable to complete the construction. And that's really what it comes down to. The ROC's position is as long as you're financially able to complete construction, we're going to provide you coverage under the recovery fund because then you can occupy your home, then you can qualify as Class 3. But as you pointed out, if something happens and you're financially not able to, you just don't have the financial wherewithal that maybe some other people have to complete construction, the Registrar of Contractors' position is in that place, you get no protection. Indeed, the people who require the protection of the Residential Recovery Fund the most get absolutely no protection, while those who need less protection are the only ones that qualify. We believe that that's an improper determination. Because when you look at what the Contractors Residential Recovery Fund, he's correct that when it started out in the program in 1981, it was all owners of property, then all owners of residential property. As long as you own property that was residential in nature, it was zoned residential, it was in a residential subdivision, it was purchased as a residential construction lot for construction of a residential home, you qualify both under the recovery fund and as well as Class 5, which it was called at that point, because you only had to have it residential in nature. The problem occurs, and the statute says that if you finish the construction and you're actually able to occupy it, then we're going to allow you to be able to qualify for the recovery fund. Or it says if it's under construction, in other words, if you intend to occupy it when it's completed, then you're covered under the recovery fund. It was that way for 17 years, from 1994 until 2011. That was the rule. In 2011, a completely unrelated amendment to the tax code, a major overhaul of the tax code involving 123 pages of revisions to the tax code, weeks and weeks of hearings as to the effect of that, had an unintended consequence to the residential recovery fund. Now the tax code was changed in 2011 to say we're no longer it's used for residential purpose. It uses the owner's primary residence, meaning that in order to qualify for tax code 3 status, you have to actually be able to use it as your primary residence. You're not allowed to if it's not completed and a certificate of occupancy has not been issued, which creates an impossibility. The ROC argues that you can still intend to occupy it and somehow qualify, but it's impossible to qualify as Class 3 and intend to use it upon completion, because Class 3 requires that you are already using it as your primary residence. In other words, in 2011, the legislature did something to the tax code for tax purposes, but nowhere in that entire discussion do they ever say, we also intend to eliminate the qualification in the recovery fund that you can qualify if you intend to occupy the residence.
I think your discussion, though, I think the issue is tougher than you acknowledge for your side, because as I understand it, the dilemma arises in 1987 when the legislature does two things. For the first time, it references the tax code, says that the property needs to be a Class 5, then Class 5 property, which means it needs to be a residence. But then also, at the same time, amended 321131 to require that the owner actually occupy the home. So you've got an interim of time when the ROC statute does require actual occupancy.
You're right. And I think that actually strengthens our argument, because what it indicates is that the legislature played around with the idea that the Registrar of Contractors is advancing now. You have to have actual occupancy. And from 1987 until 1994, that was the standard. But then the legislature came in and rejected exactly what the Registrar of Contractors argues today, which is that's too narrow of a restriction. We want to make sure it's not only people who are able to occupy, but also those who intend to occupy. And so they expanded the coverage in 1994 to cover those who intend to occupy. And when you look at how this works in the real world and what the purpose of the recovery fund does, you can see why they made that change. You know, when you start a construction project, there are different areas when you have vulnerability. And those there's a real problem in the industry of dishonest or even just honest but financially insolvent or irresponsible contractors take an owner's money and then either not perform the work or perform it in such a deficient way that it leaves the owner holding the bag to repair the deficient work. So that has a chilling effect in the industry. If you're always afraid you might get taken advantage of by an unscrupulous contractor, you're less likely to invest in real estate and real estate development and in buildings. And so we address that. In the commercial field, we do that by having bonds, performance and payment bonds, which says this is going to guarantee the contractor is going to finish. This building here, when it was constructed, by law is required to have a bond posted. But we don't have those same bonds in the residential field. The costs of doing so just aren't justified. And so to provide homeowners with some guarantee that they can safely invest, the Residential Recovery Fund is created. And what it says is up to a point, up to $30,000, if your contractor takes your money and leaves or does deficient work and leaves, the kind of things that would be covered under a bond, then we're going to step in and we're going to pay. And how that happens is the contractors are required to pay into the fund. The money Ravencrest paid into the fund, the Residential Recovery Fund. Then if you qualify, you can get that money back. And importantly, and this is a critical function, it also gives to the Registrar of Contractors incredible power to go after the contractor when they leave. We have sued Ravencrest. We can't get to that $40,000 anymore because there's the corporate veil. The Ravencrest, he took the money, Mr. Lutz took the money, he left an empty shell, there's nothing to recover. In the commercial field, when you post a bond, the bond says that the bonding company, the surety company, then has a personal claim against the owner, Mr. Lutz, and they can recover. The recovery fund does the exact same thing. It says that the registrar of contractors can then pursue Mr. Lutz personally and get that money back. The reason why that's important is because not only does the recovery fund give homeowners the confidence to invest, it also holds contractors responsible. The problem here, one of the injustices, is that Mr. Lutz has taken that money and he's gone and he's scotch-free. Not only are we have injustice because we didn't get the money, but he's gotten it and there's nobody that can come against him unless the residential recovery fund applies. So that's one reason why we want to do that.
But we can't construe the statute just because it would be nice for folks who are harmed to have a remedy, as their adversary points out. It may be that it's not supposed to apply to everyone. What do we do with the pretty plain reference in 1131 to a Class 3 requirement?
I think that you can apply, in some states and in some of the cases that we cited, it says that you can look back at what the statute was at the time when it was referenced into another statute. A specific reference can be referenced back. I don't think you need to go as far as
well, but
just
the
as
problem with that is at the time that that the tax code was engrafted onto 1131, the legislature also amended 1131 to require actual occupancy.
Yes. And then they went back and said, that is not what we intend. We intend it to be at that point it was Class 3, that allowed for somebody to have Class 3 that they intend to occupy in the future. And that's what we're asking you to apply. And here's the rule, I think, that gets you there. You don't have to go as far as the dissenting opinion that Udall had in the Nelson case, where he argued you should always go back to the enabling statute and look at what it was at the time when it referenced the other one. I don't think you need to go that far. What you can do is look at the statute itself and determine if a subsequent amendment of a referenced statute inadvertently changed this statute. And if you find within the language of the statute itself, then it's, as Justice Scalia said, it's the dog that didn't bark. There is obviously an unintended consequence. And in that case, I think you can apply the rule that then you can say, okay, if it's an unintended consequence for the amendment, we can look at what it was at the time when the reference was incorporated. And at that point, in 1994, it was intended to be occupied. We clearly meet that definition. And so if you look at the time when people can be harmed during construction, which is really what the Registrar of Contractors is supposed to do, and I think that's one of the things that's frustrating for the Knoxes, is, they know that they were intended to be included within this statute because it specifically says if somebody takes a deposit and does no work, then you're supposed to get your money back. And that's exactly what happened to the Knoxes at that point.
I suppose, though, a way that the ROC would have the statute would give meaning to all the terms by saying that the intended to occupy refers to a contract to improve a home. A Class 3 home needs to be totally redone such that the owner needs to move out. He makes a deposit and no work is done. In that situation, he intends to occupy it. It's a Class 3 and he gets his deposit back.
Yeah, I don't know if I agree with his position that if you have moved out of the home and you aren't living in the home, you're not using it as your primary residence, if it still
I
qualifies
think that
as
was
Class
my
3.
suggestion, not his.
It- Well, I like your suggestion. Right? I don't think that the statute is, and he's saying, well, you can petition and maybe you can do this, and I haven't looked at the case that he just cited to see, but that's not what the language of the statute says. The language is very clear. For a Class 3 property, you have to actually be using it as your primary residence. If you move out for 6 months or a year for a remodel, you can't use it as your intended, as your primary
I would doubt that
residence.
the tax people are that
You're right.
detailed, but
Maybe you get away with it, but that's what the statute says.
talk to us about the contract and why the $40,000 or $50,000 was refundable. It wasn't denominated as a deposit, was it?
No. And the statute, actually, if you look at the statute, which I have up here, if the claimant has paid a deposit or a down payment and no actual work is performed, the contract envisioned a $5,000 non-refundable deposit. We paid that. We've never asked for that money back. That's just what the contract said. The contract then called for a draw, which would be a down payment. That's your next draw for the next portion of work to be performed. And for that, Mr. Knox sent an email to Mr. Lutz and said, hey, normally we would have to wait for this, but I will give it to you in advance if you promise to give it back to me. And we
Did it
know,
say that exactly, or did it say when the financing comes in?
well, it says, and it's hard to read that email, but he says, I spoke with the bank and they said that the first draw is available upon signing the loan and is designed to cover the deposit for permits, etc. I could front to Ravencrest builders a deposit if it is returned to me when the bank funds the first draw deposit to you.
That's a contingency where that wasn't fulfilled.
You're right, in the sense that
What do
I
we-
don't think anybody anticipated at that point that he wouldn't get.
I understood,
wouldn't
but
get
so
paid.
what does that mean? So how does this turn to is it a deposit or a down payment?
He refers to it as both a draw and a deposit. What it is what he says is here is designed to cover the deposit for the permits, etc.
Were the permits pulled?
No. No permits were pulled, no mechanics liens were filed, no subcontractors were hired, no work was performed, no porta potties were delivered. None of the stuff that's in the contract that says it's going to be done, none of that was performed. And the evidence of that was presented at the lower court. We presented affidavits. We presented that we had searched for mechanics liens. We had the emails from the parties, from Mr. Lutz saying, okay, I'm going to pay you back. The payment of $10,000 and then him absconding with the other $40,000. And that was reviewed by the trial court and was never challenged by the registrar of contractors below. They could have taken the deposition of Mr. Lutz. They could have, I guess, done subpoenas to them. They could have found subcontractors that have performed work. They could have found permits. They didn't do any of that. They just said this is a possibility. So the trial court below looks at that evidence and makes the determination that there was a contract, that the amount had been paid, and that that amount was owed back. So when he says his ruling, he's not relying only on the default as a basis for it. He says, after having been given the opportunity to assert defenses that Ravencrest did not raise in this case, the facts were determined by the court. Reserving objections which are no longer supported by facts determined by this court is not sufficient to revise an abandoned defense. And that's critical. He said, okay, you've said that you have these defenses, but I have actual evidence in front of me and you've never responded to them, so I can't let you continue to assert unsupported defenses. I think that the thing that really is the court has to struggle with is you've got to find a way to give meaning to all of the aspects of the statute. And what is the meaning of the statute if intent to occupy is now an impossibility because to get Class 3 you actually have occupied? Intent to occupy becomes irrelevant at that point. And the other thing you need to look at is the discussion of down payments. The statute is very clear. It's not a down payment that construction was later done. It says in there that it's a deposit or a down payment where no actual work is performed. So how do you have?
But that could be on a remodel.
It could be, I guess.
And
You
maybe
could make
that's
it.
maybe that's all the legislature was intending to cover.
You
was
could
a
make it
remodel.
so narrow that it could be that. But is that really what the intent was? Because for 14 years, up until 2011, when this completely unrelated tax code change is made, for 14 years, there's no question. The Knoxes qualify, right? They've always qualified during that period. That's why that bar is green up there. From 1981 to 2011, there's no question they qualify. In It's not until 2011, when a completely unrelated statute with no discussion of the Residential Recovery Fund or an intent to impact the Residential Recovery Fund, no hearings, no analysis, no asks the Registrar of Contractors provide information. It's not until that unrelated event that it creates this technicality that now the Registrar of Contractors uses.
Changing topics, on your request for attorney's fees under the private attorney general doctrine, the ROC points out 321132A, which states that the fund shall not be used for attorney's fees except in contested cases appealed to the Superior Court. And there's, as you know, a whole regime of ROC cases that may be appealed to the Superior Court. What's your response to that?
I would agree that under the Residential Recovery Fund statute itself, there's not an avenue for recovery, and that's why we cited to the private attorney general. There would have to be some other instance for it. I can tell you one of the reasons I'm here is I spent the last 25 years of my life doing construction law. This is a big issue. This affects people, and I'm here not only to help the Knox, but because I think that it needs to be righted. We sent a request, a public records request to the Registrar of Contractors asking how many other people like the Knoxes are being denied this access to the recovery fund by this technicality that they're relying on. And they've refused to give us that information. We don't have it. So I can't give that information to you. But this matters to people. It affects people's lives, right? Mr. Knox and Mrs. Knox, the people who the statute was designed to protect, the people who the legislature specifically said, we want to give you your down deposit. They not only lose their house, he loses his job, he's financially unable to proceed with the completion of the construction, and he loses that $40,000 for now going on 3.5 years. These are people that are harmed. These are real lives. And the frustrating thing is these are the people that were supposed to be helped by the Residential Recovery Fund. And the legislature told us that. And so in this situation, I think it's proper for you to look at the amendment to the tax code in 2011 and say, was this an intended consequence or was this an unintended consequence? As Justice Scalia says, the dog that didn't bark. And we think that you'll come to the conclusion that this was intended to cover the Knoxes. They should be covered. And so you should apply what was in place prior to the 2011 amendment. It's the only way to make sense of the statute.
Thank you. Thank you to both of you for your arguments and for your briefing. We'll take the matter under advisement and issue a decision in due course. We'll adjourn now briefly to allow the next group to set up.